See my screen, right?
Yes, sir, we can see. But
Right.
only, yeah, that's moving. Yes, yes.
Correct, no?
Correct. Yes, sir.
Right. So you'll have learned about this. So in Sri Lankan context, we have Code of Best Practice on Corporate Governance, 2013 and 17 amendment, right? So these are compulsory rules for all the listed companies. In addition to that, we have corporate governance for licensed commercial banks, number 11 of 2007. That's again corporate compulsory listing for all licensed commercial banks. These are being implemented on all the commercial banks, especially systemically important banks. Central bank comes very regularly and check those uh, requirements. Now, that's why I said it's more than directors of the company, more than shareholders of the company. Now, say our appointments, we go as key management personnel in the bank. So we are called KMPs, right? Any appointment to these roles, KMP roles, Chief Internal Auditor, Chief Risk Officer, CFO, uh, Chief Compliance Officer, right? COO, Chief Operating Officer. All those roles are C roles, right? C roles are held by KMPs, Key Management Personnel. Now, I being a key management personnel, for example, my appointment need to be approved by the central bank. I need to be cleared for fit and proper to hold this position, right? So every quarter I have to submit multiple disclosures from my side, my family members, our borrowings, our investments, kind of asset declaration to central bank on a regular basis, quarterly basis. We have to submit that, and if they see that we are not up to the level that is expected, they will not. And if I am moving from this role to another role, right? So I am a KMP, key management personnel, to hold CIA position, Chief Internal Auditor position. So if there is a vacancy in the, say, for example, IT department, right? So vertical head of IT has left, so there is a vacancy, and the management of the bank thinks that Niroshana Seriviratne is good enough to take that role, right? So even I can't laterally move, right? For KMP to another vertical, there again, it requires central bank approval for me to take over that role, right? So it is so stringent to that level in managing our affairs, right? So Companies Act 2007. Now, most of the time under corporate governance, we tend to miss this part, the Companies Act. So I think the main base for corporate governance, the main act governing corporate governance is Companies Act, right? So I will deal with little bit on Companies Act. Then we have CSC listing rules, Securities and Exchange directives, Central Bank of Sri Lanka directives, Code of Best Practice. This is the corporate governance framework of Sri Lanka. Uh, so this is the framework that we are working in. Code of Best Practice, Banking Act, Directions, Basel, then the Companies Act. Companies Act is very, very crucial for us to understand corporate governance better. Okay, right. So I will skip this. Right. You may have learned conformance and performance, right? Corporate governance has to come as conformance, not as performance. Now it's like a car, right? Uh, car, car engine and brakes, right? Corporate governance is the brakes. Okay, car need to perform, right? Without company performing, there is no point having corporate governance, right? So first, we all need to encourage the performance of the company. Company need to do its business, get transactions, get it off the ground, and do its business on a continuous basis. Then only the corporate governance part comes in. Otherwise, if you start with corporate governance, there's no movement of the car, right? So that is like you keep your leg all the time on the brake pedal, corporate governance, car is not going to move. So we need to move the car first, then only the brakes will work, right? So the conformance part need to come in after company starts performing well. Okay, so governance part is the left side, where the accountabilities, then the audits, compliance, risk management, board subcommittees, all this comes in on the conformance part. Performance part is the business, their value chain creation, their marketing, all that need to run. And with regard to auditing, right, uh, the framework, what we need to understand is auditors, internal audit scope is very wide. We have the corporate governance box. Within that, we have risk management box. Within that, we have internal control box. And internal audit will have to process or rather review all those processes, whether the internal controls are intact, the COSO models, then the risk management is intact, the COSO model ERM, then the corporate governance, right? All what we discussed now need to be ensure that everything is in line. It is the responsibility of the internal control, and internal control is also part of corporate governance. So that is why it is complex. Internal audit need to ensure all those. At the same time, he is also part of corporate governance framework. Is it clear? Right. So let's move on to Companies Act, what it says about directors, right? So this is very, very critical for corporate governance. You need to really understand who is a director, how a director is being appointed, how a director can be removed, what are their responsibilities, right? So on and so forth. Then about shareholders, what does the Companies Act says, right? So definition of a director is given in section 529 of the Companies Act, right? It says a person carrying the position of director of the company by whatever name you call it. You can call different names, but if they are directing, right, and they are holding that position, they are called directors, right? So you can't get out of it by giving a different name, saying promoters or something like that. But if they continue to do that job, then they become directors. On whose directions or instructions that the person may be required to act, whose directions or instructions the board of the company may be required to act, right? Directors, his his instructions, where the company will be acting, a person will be acting. At the same time, the board of directors will be acting based on that person's instructions. So that person becomes a director, right? Entitled to control the powers which would be required to be exercised by the board. Okay, so that's a definition, broader definition. Who is a director? Director is a person who is sitting in those positions, directing people, directing the board, and also exercising his powers. That person becomes a director, whatever the name you can call him. He is a director. Okay. Is it clear?
Yes, sir.
Yes, sir. Clear.
Right. Then appointment of a director. So section 201 says a company shall have at least one director except a public company which should have at least two directors. Okay, that's the minimum. You need not have 13 directors, right? HNB is a company registered under the Companies Act. However, we have 13 directors. Minimum is public company, two directors. We need to have two directors. Is it clear? Right. 202. Any person who is not disqualified, the following person shall be disqualified from being appointed or holding the office as a director. Right? So we need to be a person who is not disqualified to be appointed as a director to be appointed as a director. Who are the disqualified people? A person who is under 18 years of age, a person who is an undischarged insolvent person, a person who is prohibited from being a director. There's a court ruling before. A person who has been adjudged to be of unsound mind, a person that is not a natural person. Who is a natural person? Non-natural person. Who is a non-natural person? Example?
Companies, registered companies.
Registered company. Okay. Can someone tell me what is the difference between a human person or natural person and a non-natural person? These are very important points.
Human person can think, but natural person can think,
Okay. Okay.
but legal.
Other than that, there's a vast fundamental difference. Anyone?
Decision making.
Come again?
Decision making.
Decision making. Okay. Human can think. That is the point, no? Human can think. Non-natural person cannot think. Okay. Other than that, main point is all of us, you and I, are natural person. In a legal interpretation, natural persons can do anything that we want, but cannot do what is prohibited by law. Understand? We can't attack a man, we can't kill a man, right? We can't steal, right? We can't rob, right? Understand? So all these are restricted by law. Other than that, we can do anything. Right? You can sing, dance, talk, anything you can do, which is not restricted by law. But a non-natural person, that's a company cannot do anything, complete opposite. Company cannot do anything other than what is said in what? What is said in
Set by directors.
Articles of association.
articles and memorandum of association of the company. Okay. So they can only do that. If they have formed this company to do banking business, they have to do banking business. They can't buy and sell fish. Okay. So that is the complete opposite of a natural person and a legal personality. Okay. So that is why it is saying a legal personality cannot be a director. Right. Section 203, get hold of the Companies Act and check those. A person shall not be appointed as director of a company unless he has consented to be a director. He need to have that consent. So that consent, there is a form. He has to sign that form and give it, right? So when we are auditing corporate governance, we always see whether those directors, 13 directors, have given their consent in terms of the Companies Act, Section 203. Otherwise, his appointment is null and
Void.
void. Null and void. Okay. 204. Be appointed by ordinary resolution. Directors are appointed by ordinary resolution, mostly at the annual general meeting, or in between also, they can have ordinary resolution. 206. Be removed by ordinary resolution. 210. Maximum age limit to become a director is 70 years.
So, small
Right?
question. Mr. Adit Kotalawala hold many directorship in Selinco Group, even though he has more than 70 years.
Yeah, so that need to be ratified at a extraordinary general meeting in that case. Right. So somebody can question all the time whether it is within the timeline of Companies Act 210. So he may be violating it. He can always use the special resolution to get him appointed. So shareholders collectively at a special resolution, they can appoint extend the period of 70 years. There's another limit also, maximum 79 or something like that. Good question. Right. So there's another issue that comes in where directors have a fiduciary responsibility or fiduciary duty towards the shareholders, right? So there are decided cases again to say that they don't have a fiduciary duty. Fiduciary duty means they have to do utmost trust and confidence, right? And 100% act on the interest of shareholders, right? So what is fiduciary duty? There's a definition. An individual in whom another has placed the utmost trust and confidence. So shareholders, whether they have put utmost trust and confidence in directors, that's a question. To manage and protect property or money, right? So this fiduciary duty comes in if I appoint a trustee to manage my property. So I put utmost faith in that person and I appoint him. If there is a minor's property is being managed by a trustee, then the minor has kept utmost trust and confidence in that person. So that person has a fiduciary duty towards the minor, right? So shareholders and directors relationship is not to that extent. That is why it says directors have no fiduciary duty towards the shareholders. They are the ones who appoint directors. However, they don't have a fiduciary duty towards them. The relationship between, relationship wherein one person has an obligation to act for another's behalf. So directors are acting on shareholders' behalf, but however, they have not put 100% trust in directors. So that was proved in decided cases. Percival versus Wright held that directors only owe duties of loyalty to the company, not fiduciary duty. Okay, Scottish Company Corporate Society mayor, that again they decided that it's not a fiduciary duty. But in one case, Coleman versus Mayor, this is for your information only, these will not be checked at the exams. Directors owe fiduciary duty to shareholders if there is agency relationship that specially arise between shareholder and director. Company was a small family company and shareholders heavily dependent on Mr. D, director, for information and advice. So therefore, he had a fiduciary duty. So if it's a family-owned company where children and family is not financially literate, then they will appoint directors. So they will be heavily relying on that director to act on their behalf. In that case, they can be proved there is a fiduciary duty. Otherwise, there's no fiduciary duty. In that case, directors need not act all the time for the protection of shareholders. So these are the complications that come in the corporate governance, right? So shareholders will shout and say, okay, we have appointed you, you have to act on our behalf. What have you done, right? No, it is not the case. There's no fiduciary duty. They are not bound to act on shareholders alone. They can act in the interest of the company, in the interest of the other stakeholders as well, or sometimes their own interest. Okay, give me a second. Right. Okay. Section 187. These are very important parts, right? Act in good faith and in the interest of the company, right? Now, this is where it comes in. Wholly owned subsidiary of another company, then act in the interest of the holding company, right? This is the first thing that we discussed, right? Decided cases, Scottish Corporate Wholesale Society versus Mayor, where they decided that the director of a subsidiary need to act in the interest of the shareholders of the holding company or the parent company.
So I got one question.
Yes.
If this that good faith and the interest cannot be measured, so how can exactly say the director is with the good faith and good intention about the subsidiary? How can we
Correct.
measure it?
So when you're being appointed a director, you need to be mindful of your responsibility, right? So if shareholders, most of the time, they will not understand what my role is. If I'm a director, they appointed me, okay, fine, thank you very much. So now I have to look after the company and make decisions based on my capability, my acumen, right, and best interest of the company. The major shareholder who appointed me will question me and say that, look here, I appointed you to safeguard my interest, right? You are not taking care of my interest. By you doing this, all my businesses, that business should come to me, right? Because you made that decision as directors, I lost business. Understand what I'm saying? Right? So then I need to be able to explain to him, so sorry, sir, I can't be giving any favorations to you, right? Under corporate governance also we learned,
Yes, I got it. Got it.
okay, equality, equity, all that is required to be done, right? Now say in our bank, Mr. Harry Javardhan Stations Group also have major shareholding, right? So they also appoint directors. Okay, so they are shareholders, they appoint directors. But the moment the director comes into the board, true, that director was supported by that group. So he can't make decisions in favor of that group. Understand? But those shareholders may be expecting him to act in that level, that line. But it is not my duty to do that. My duty is to do this, like parliamentarians.
Got it. Okay.
Right? Right? One group appoints them, right? Moment they come into, they become one of 225. So they have to look after the interest of the opposition also. Right? They can't make decisions only favoring the party they appointed you.
Yeah, most of
Right.
the government, all these boards like a co-op committee and all those committees they are biased to the government, no?
Yes,
So
yes,
in that case, those are not actually good faith and the interest to the what we call the country. They are
correct,
interest to the
exactly. Now,
running government.
exactly. So ideally, these corporate governance rules also need to apply to those institutions as well. So sadly, only the corporate governance rules are applied to private sector, listed companies, so on and so forth. Right. So government organizations, the all those other companies, they have directors, right? They have shareholders, right? Those structures are there. So all these rules will apply to them as well. So that is not being done. Sri Lankan Airlines, right? Telecom, Leco, all these companies, they have their boards, they have Litro, all those companies, right? Uh, right. Section 188 says to comply with Act and Articles of Association. Board of Directors, their responsibility is to comply with the Act, that is Companies Act 2007, at the same time, Articles of Association of the company. They need to be governed by that, not by the shareholders. Right? Section 189, standard care and skill shall not act in manner which is reckless or grossly negligent, and shall exercise the degree of skill and care may reasonably be expected of a person of his knowledge and experience. If I am a chartered accountant and I am being appointed to the board of directors, so I need to, right, a person of his knowledge and experience. They expected certain level of professionalism from me. So I need to be governed by that, right? If I am just a layman, so I need to exercise my knowledge and experience. If I am a qualified lawyer, I need to be guided by that, right? But I may not have a single qualification, but I have heaps and heaps of experience in some field. So I need to live up to the expectation of that experience. That is what it says, Section 189, right? So interesting case, Butte's case, right? Cardiff Saving Bank, they appointed MB was appointed when he was 6 months old, right? It's a family-owned bank. Cardiff Savings Bank appointed a director who was 6 months old, baby, right? For 38 years, he has not attended a single board meeting. So, what is the knowledge and experience that you expect from that person? 6 months old baby, right? So, that's also a famous case. Section 190, use of information and advice. A director of a company may rely on reports, right? If they ask for financials, if we give them window dress set of financials, okay, cooked financials, he will, if he relies on that, we can't blame him because we have misled him, right? He will be asking for MIS. Okay, give me a list of these transactions. So we give a list of transactions, taking out few transactions, right? So he will rely on that transaction, whatever the information given to him, he will make decisions. You can't blame him later that he has not done that. So this is the protection for directors, Section 190. Use of information and advice. A director of a company may rely on reports, statements, and financial data and other information if and only if the director acts in good faith, makes proper inquiries, C, has no knowledge that such reliance is unwarranted, right? If he acts on good faith, he got some information, acted on good faith. He made certain inquiries. They gave all false answers, right? So he relied on that. So he can be exonerated from his responsibilities. Section 199, a director of a company shall not disclose that information to any person or make, so whatever the information that he gets, he need to maintain confidentiality. Now this is very interesting. Directors' interest in contracts, right? When is there seated at the board, right? All 13 members. One of the directors of a company is interested in a transaction to which the company is a party if and only if the director, right? So they're going to give this business to, they are having two suppliers, supplier A, supplier B. I know supplier A very well, and I am a director of that supplier A company, also in addition to being in the bank. Okay. So how do I handle it? Right? So if the director is a party to or will or may derive a material financial benefit. So when that company get this business, the profits will go up. As a result, my pay also will increase. I'm going to get substantial financial benefit. Has a material financial interest in another party, right? All these conditions, if those meet, what do I have to do? I have to say, yes, look here, company B, I'm connected, I'm a related party, right? Can you note it down? So the secretary, company secretary, will note it down that Mr. So and so raised his concerns that he is a related party to that company, and this transaction, he said that he is a related party. He disclosed his connectivity to that party, right? So you just have to disclose only. Additionally, yeah.
Excuse me,
Hmm.
if any director do not reveal that kind of personal favoration or personal interest, what is the punishment, or are there any kind of charges against that director?
Yeah. So
What?
he is violating section 191, right? So 191 says you have to disclose that. Now
Yes.
purposely I keep quiet. Nobody knows, right? So I'm violating section 191. Under section 191, I can be taken action against me is a punishable offense.
Okay, so then what kind of punishment that if the company court
Correct.
or
That again, Company Act says for all these violations, what is the punishment? I can't remember. Maybe 6 months imprisonment or something like that.
okay.
Right? Fine was 6 months maximum, 6 months imprisonment or something like that.
Okay.
So Companies Act, if you go through the Companies Act, those punishments also will be are also mentioned there. And also this is the reason that there is a related party transactions committee. Under corporate governance, you may have learned audit committee. There are compulsory committees, right? Audit committee, risk committee, nomination committee, remuneration committee, right? Related party committee, right? So there is a separate committee looking into the related party transactions. Okay, right. Section 192, duty to disclose the interest of the directors in transaction forthwith after becoming aware of the fact that he is interested in a transaction, a general notice entered in the interest register or disclosed at the board meeting. So he can raise his hand and disclose that I am a connected party. I need to be excused, right? That's the additional thing. The Company Act doesn't require that, but normally what happens, they say I'm a related party. I would like to move out of the room until that is being discussed and taken a decision. Okay, so that's the right way of doing it. And also, as per the Companies Act, as far as you have disclosed your interest in that, you can even vote in support of that. Right? You can vote against that. You can do whatever it is, because sometimes the moment that director goes out, the quorum issues will come in. Right? The minimum number of directors need to be there to make a decision. Right? So therefore, Section 196 covers that. Director of a company who is interested in a transaction may vote on a matter relating to the transaction. Fine. Having disclosed that, he can vote. Attend a meeting of directors at which a matter relating to the transaction arise and be included among the directors present at the meeting for the purpose of quorum. Sign a document relating to the transaction on behalf of the company and do any other thing in his capacity as a director in relation to the transaction as if the director were not a party interested in the transaction. As far as you comply with your section 191 and 192, you can just operate as if you are not a connected party. So those provisions are there. Is it clear, no?
Yes, sir.
Right. So, and similarly, Companies Act also talks about shareholders, right? Section 87. A shareholder shall not be liable for any act, default, or an obligation of the company, right? If you have purchased shares of HNB, right, you are a shareholder, right? You are not liable for the transactions or the failures or the closures, right, of the company. You're only responsible for the, by reason only of being a shareholder. The liability of a shareholder to the company is limited to any liability expressly provided for in the Articles of Association. Liability, company's liability. Now we are dealing with some companies, their liability, their shareholding is about 20 rupees or 200 rupees, right? So they have borrowed millions of rupees from banks, right? So the shareholders, if you are a shareholder of that company, your liabilities up to rupees 200, not to anything more than that. Is it clear? Powers reserved to the shareholders of a company by this act may be exercised only at a meeting of shareholders or by a resolution in lieu of meeting a shareholder. Right? So shareholders can exercise their powers. They can't walk into the boardroom. Right? I'm a shareholder. I want to get involved in my company's decisions. No, they can't walk into the room. They can't make decisions. They can only raise their hand, object, or give at the voting at a general meeting, shareholders meeting. Okay, so that's their right. That's it. Unless otherwise provided by this act or in the articles of the company, a power reserved to shareholders may be exercised by an ordinary resolution. At an ordinary annual general meeting, he can raise his hand, he can raise all his questions and vote in favor or against of any decision. That is his responsibility, his right, not anything else. Now, Section 92 is very important. Notwithstanding anything to the contrary, containing in the articles of the company, when a shareholders exercise a power, one, alter the company's articles. If they are altering the company's article, you can't do that at a general, general meeting, ordinary general meeting. You can't. It has to be a special resolution. Approve a major transaction. Major transaction, there is the separate definition for major transaction. Approving a major transaction, again, you need to pass a special resolution. Approve an amalgamation. Again, special resolution. Reduce the company's stated capital. Special resolution. Resolve that the company be wound up voluntarily. Right? Need a special resolution. Change the name of the company. Need a special resolution. Change the status of the company. Right? Private limited to public limited to private limited, guarantee limited. All those conversions need special resolution. Special resolution has to be passed with a 75% majority. Right. Any question? No questions? Right. So corporate governance principles, right? So corporate governance principles. Now one of the banks, right? This was public information, so I can share. One of the banks chairman, right? Very recently this happened. Chairman. Now there's in addition to these rules, if a director of a company, right, director of a bank, if that person is going to borrow from the bank, right? So I am a director, for example. Questions? Right. For example, if I am a director of a bank, right, I also need to borrow money, right? So I am borrowing from the same bank. If I am borrowing from the same bank, since I am a director, there is a regulation by central bank to say that my borrowing has to be 100% secured. Is it clear? Are you all with me?
So secure means?
Yeah. So when you go to a bank and borrow, right, you want a loan of 1 million rupees, right? Bank will ask, what is the security that you can give? Okay. You will say, I have a fixed deposit in another bank. I can borrow against that. So that is a security. Understand? Or you will say that I have a house. I can mortgage my house as security and get that loan. Are you with me?
Okay, so understand.
Okay. So that is security. So if I am a director of ABC Bank, okay, and if I am going to get 200 million for my business, my own business, right? The regulation is such that that 200 million has to be fully secured by cash. Okay, I can only borrow cash basis from that bank. Okay, that is true with my spouse. That is true with my son. That is true with my daughter. That is true with my closely associated related party. Right? So any of them going to borrow from ABC Bank, where I am a director, all those facilities need to be, all those loans have to be 100% secured. Understand now? Yes or no? Are you clear?
Yes, I got it.
Sir, as a mortgage, sir, can we have to have some sort of a cash related thing, or can we mortgage any non-movable like say assets, sir?
Yeah, correct. That is also possible, but that also need central bank approval. So what the guideline says is it has to be cash backed. We need to back it. So back it with cash. Okay. So this happened in one bank where the chairman of the bank, chairman did not borrow, chairman's spouse had a company. Okay. So as per the guideline, it is the director, director's spouse, director's children, like that. Okay. So it doesn't talk about director's spouse's company, right? So this director's spouse, he was a director of a family-owned company. So that company borrowed from this bank. Okay. So in that case, it is subject to interpretation whether that need fully covered security, right? So that bank interpreted that it is not required because the regulation says director, director's spouse, or director's children. It doesn't talk about spouse's company. So bank lent to the spouse's company. So therefore need not secure. So central bank came in very harshly on that. And the regulation says if you do not do that, that director is said to be vacated post. Director has not disclosed. So he has violated this. So since that date, he has vacated post. So therefore, they came very strongly. Chairman of that bank had to exit from the bank. Okay, so that is so serious to that level. If you violate any of those, this is subject to interpretation, right? In the spirit of the law, yes, it is expected that chairman's spouse's businesses also comes under spirit of the instructions. But as per the act, it is only spouse. So this one, Central Bank was very strong on that. So they treated that director, the chairman of that company, bank, as vacated post. To understand the seriousness of those, right? Just example to understand the seriousness of the transactions. Right. Under corporate governance, we have gone through. There are 33 principles, right? Out of that, 23 principles are for directors. Balance 10 principles are for shareholders. So these are the directors related principles, all of them, 23. And these are the shareholder related principles that need to be applied, altogether 33 principles. So statutorily, it is required that the board, these 5 committees are required: board nomination committee, HR remuneration committee, audit committee, related party, board integrated. So you all have gone through this. So these are the ones. Without explaining, in the interest of time, I will show you the real reports of board audit committee, nomination committee, integrated committee. This audit committee report of HNB. This can be seen, right?
Yes,
Can you
sir.
all see?
Yeah.
Right. So this appears in the annual report if you get hold of annual report. So this says the composition of the meetings. The board audit committee comprised of 5 non-executive directors, of whom 3, including the chairman, are independent directors. They are non-executive directors, right? 3 of them are independent directors. So independent non-executive directors. Who are executive directors? Who are involved in day-to-day transactions. So non-executive directors they are not involved in day-to-day transactions. And out of the 5, there are 3 who are independent directors, not supported by any major shareholder. Right? The following directors served on the board of committees: Mr. Devaka Kure, right? He is the chairman of the audit committee. But to date, he is the chairman. Mr. Ashok Piris, Dr. Karunaratna, Susi
Sir,
Captain,
excuse me.
Niraj. Hello?
Not visible, sir.
This is not visible?
So the report, yes. It's not visible.
Huh?
Report not visible.
Only the slides
Report-
can be seen, sir. Yes, not the
Oh.
report.
Oh. Is it visible now?
Yes, sir.
Yes, yes.
So this is the audit committee report. So left-hand side, they say, okay, the board audit committee comprises of non-executive directors, of whom 3, including the chairman, are independent directors. So it gives the names of the directors: Mr. Devaka Kure, chairman; Mr. Ashok Piris, Dr. Karunaratna, Rusi Captain, Nilanthi Silva, Damien, Madhuratnayaka. All those are directors. Whether they are independent, non-independent, all that is there in front of their names, right? Then how many meetings they held and how many they attended, right? They have had 10 meetings. Out of the 10 meetings, how many they have attended. So board audit charter, what does the terms of reference of the charter says? Key responsibilities of the audit committee, that is being spelled out here. Then the authority of the audit committee, that is said here, right? Focus of the attention of the committee: financial reporting, 40% of the attention; external audit, auditors engagement and policy, right, 20%; internal audit reports, internal audit controls, 30% of their time, right? Activities, all that is said. And who are the attendees, regular attendees of the meetings? So names are here. Financial reporting, external audit, what they have to do, significant accounting and judgment considered during this period. For the reader, for the public, they're telling all that. So about internal controls, what are the controls that they had or any controls that were breached? Internal audit side, what are the things that they discussed and what are the improvements they suggested? Training and development for the board, committee evaluation, and finally, chairman of the board signs. So that is about audit committee meeting, how they structure that meeting, number of times they have met, how efficient they were, what are the things that they discussed during the year for the public. Now, how can the public question them? Like you all question me, how can the public question them? Public or the shareholders? So they just publish this, that's it. Is it? No, this is included in the annual report. Okay. So at the general meeting, shareholders are there, right? 17,000 shareholders will attend through proxies individually. They can question, they ask, okay, so you have only met 10 times. Okay. Is it enough? So they have to answer, right? So you have spent 10% on something other. What are those others? All that questions they can ask at the meeting. Actually, they ask, right? So this is how it is, right? That's about the audit committee. Can you see my integrated risk management committee report? Is it visible?
No, sir.
No?
No, so it's still at the previous report.
Now?
Now, okay. Yes.
Yeah. Board Integrated Risk Management Committee. So this is the risk committee, right? Very similar. Risk committee composition, their members, their management participation, meetings, how many meetings that they had, right? Major initiatives by the risk committee, what their plans for the future, who attended from the management, summary of the charter, primary responsibilities of the board risk management, same, very, very similar structure that is being followed. Activities in 2022, 2020, credit risk. So how their time was spent, professional advice, and finally, the chairman of that committee signs. These are subcommittees who are responsible for those statutory subcommittees. Nominations committee. Can see, nominations committee.
Yes, sir. Yes.
Yeah, same structure, like that. Who are the people who attended? What are the things that they discussed? Committee responsibilities, all that is being disclosed. This is in line with what is expected from this committee in corporate governance rules. Understand? Right. So, these related party transactions. So, we discussed about related parties. Related party transaction review committee. So, their main task is to review the related party transactions. Related party transactions where the directors are connected into those transactions. So they review and they say they make decisions on those. Clear, right? So you can download any annual report, right? So this is
Sir,
yes.
like in practical, how does these boards efficiency is measured, sir? Though they comply with the meeting rules and everything, practically how their efficiency or the efficiency of the board is measured, sir?
Yeah. So there are very good question. There is a terms of reference for each committee. Okay. So before that, I will show you. Can you see this page? Audit committee charter. Can you see that? No?
No, sir.
Now you can see, right? Can you all see? Audit committee charter?
Yes, sir.
Right. So like that, there is a terms of reference or committee charter. Each committee is governed by these charters, or rather list of things that the authority composition of the board audit committee, right? This is one charter, okay? Then board audit committee meetings, how it should be conducted, what are their quorum, what are their responsibilities, orientation of committee members, this need to be conducted, right? This is where it is being measured, right? Product services orientation need to be given to them, foreign and domestic operation orientation need to be. So at the end of each year, these will be evaluated against them, right? So this is how we ensure that the purpose of the committee, right? This is the purpose of the committee, authority of the committee, duties and responsibilities of the committee, right? Risk management and internal controls, what are their responsibilities? Have they taken care of that, right? Financial reporting and disclosure matters, right? So on and so forth. These guidelines continue, right? So at the end of each year, they will be measured against those requirements, right? This is where the first slide says people, purpose, process, and performance, right? Very good question. This is how they are being evaluated, right?
So then who does that particular part, sir? The evaluation part is done by, I mean,
Conducted by the secretary of the board. Okay, that is that secretary's responsibility. That secretary has to do that review, right? They need to get feedback from us, right? They need to get feedback from shareholders, other directors, and submit that report to the full board. And full board will go through. There is a scoring system. So out of 10, right, all having gone through, and also we can rank out of 10. We can give a score out of 10. Okay, what is out of 10? This committee got 8 out of 10. Another committee got 2 out of 10. So they board need to review those 2 out of 10 committee and see what went wrong, right? Probably chairman has not attended any of the meetings. Okay, so he was not guiding properly. So therefore, immediately next year they will be changing, right? So this is happening on a quarterly basis. That review of the committee performance is happening on a quarterly basis. Is it clear?
yes, sir. Thank you, sir.
Yeah, internal audit oversight and responsibilities. Now here they say minimum for a year they have to have discussions. Here 5.3.4.8, the committee shall meet the chief internal auditor exclusive of management at least once a year. This is a requirement. Okay, this is a requirement. So therefore they have to talk to me, they invite me and ask me without the management, only me and the 3 or 5 members of the board audit committee asking me, okay, tell us what you were not able to put in the reports, right? There are certain things that we can write in reports. There are certain things that I can't write in reports. Understand? So therefore they will be asking. Now say if the CEO or managing director is putting pressure on me to say that, okay, don't tell board, right? This is very serious. Don't tell to the board. So that kind of pressure will come my way. So I can't put it. There's no chance that I can tell them, right? So this is the opportunity that I have to tell them, okay, this matter, I was not able to release any of the reports because of the threat that I have been facing. This has never happened, okay? So that is the reason that thank you very much for the opportunity. This is what happens on day-to-day basis. So and so is not allowing me to do this work. Understand? That is the purpose of the board of directors meeting the chief internal auditor without the presence of anybody. And that is not recorded also. All now this discussion is being recorded like that. Meetings are recorded, but this is out of the records. So I am free to tell them what I felt about the situation. Is it clear? So when the evaluation comes in, so how many meetings of chief internal auditor had with board audit committee without the management? At least one. So we have had 3 or 4. So the scoring will go up. Understand?
Yes, sir.
Yeah. Any other question? So this is a corporate governance report. Which company is this? LB Finance. Okay. So LB Finance corporate annual report, corporate governance report. Here, corporate governance report. From here onwards, principles and compliances, right? Responsibility of the board of directors, state. So they will say, approving and overseeing strategic objectives and corporate values, complied, tick. This one, approving oversight business strategies, complied, tick. Risk management, tick. Understand? Comply, comply, comply. All complied. Is it clear? Appointment of company secretary. As per the corporate governance, yes, they have appointed somebody. Yes, complied, tick. Delegating responsibilities to the company secretary. Yes, done. Are you all with me?
Yes, sir.
Composition of the board. Okay, composition of the board. Number of directors of the board, complied, complied, complied. Anything that they have not complied, everything seems to be complied. So get hold of these reports and see, then only your practical application works. Looks like they are complying with everything. Okay. So sometimes they will say not complied, and they will explain here why they were not able to comply. Right. So that ends our session. Anything that you want to discuss? Any question? Anything that any question? No questions? Right. Looks like no questions. So
Sir, would it possible to share your slides with us, sir?
all given.
Okay.
All the slides shared. Maybe that will be uploaded to the portal. Check with Kalhari.
All right, sir. Okay. Thank you, sir.
Right. So then I'll close. We'll meet next time in person at the university. Okay. Thank you very much for supporting me.
Thank you very much, sir.
Thank you, sir.
Thank you very much, sir.
Thank you, sir. Thank you very
Thank
much.
you.
Thank you.
Thank you.